You accept your responsibility now that we saw it on a video.
There is also the footage from the inside of the car where both are detained, where she actually speaks to the other defendant without the cops being there, and she talks about how she was here and you had told her not to do this anymore. But I think that first video kind of sums everything up.
All right, any evidence with regard to count 1 before I make my finding?
Evidence, Your Honor, is in testimony.
And anything that could,
I'm looking at this trying to figure out if that's a legal search. I mean, she appears to be detained, so it's not a Terry search. It's a warrantless search, obviously. She's not under arrest and being searched at the jail.
they didn't search her. They said, if you have something, take it out. She took it out and she placed it on. They didn't even have to get to the search.
I guess she could have refused and remained silent.
But she didn't, and
She
so,
followed the direction. And there's no Miranda issue since she wasn't
right.
arguably in custody. I don't have any argument. I will go ahead and object that that's an illegal search.
All right, that objection's overruled. I am going to find count 1 true. And so, let me see, I need to. Counts 2 and 3, she pled true to, so there's a finding of true. Count 2, again, everyone's had an opportunity to review that pre-sentence report. Mr. Kemmler, you may make argument with regard to
Yes, Your
punishment.
Honor. At this stage now that the state has offered evidence as to count, as to the new offense, and the court's found that to be true based on the evidence, I think the recommendation comports with the state of the record. I would, again, defer to the probation department, but I think that they're seeming to indicate that the court is to keep her on probation, that she enter into the ISF program, cognitive track, and I would defer to that recommendation in lieu of revocation.
Mr.
Or proposal, I suppose, I don't know if it's the next word.
With the pending charge of this theft, she's not eligible to go to ISF.
She's, if I may, she's set on that today. I can resolve that today in misdemeanor court.
No, it's pending in felony court.
It's here,
Oh,
it's
is it here?
mine.
Okay.
Because of the prior
All right.
thefts.
All right,
She's done with misdemeanor
right.
thefts.
We could resolve that perhaps today, Your Honor, if the court.
I mean, I'm, go ahead.
The state, I feel like we have given her every possible chance to rehabilitate, and she has not taken that. We would ask that she be revoked and given, based on the number of thefts committed, that she be revoked and sent to the state jail for 2 years.
Ms. Lopez, do you have anything else to add to your updated
No, I put
report?
everything in my recommendation.
All right.
Do you want to address the judge?
Yes. I feel like I did, how can I say this? I feel like I can finish my probation off because of the simple fact, like, this is the longest I've ever been away from my kids besides when I did 8 months, but they was younger than me, and like, I was younger, and like, they understand what's going on. And I understand, and like me being away from my kids right now is really hard because they be with my mama, and my mama had dementia, and she.
Stop with everybody else, because I'm not going to make my decision today based on the fact that you have kids or based on the fact that your mom needs you, because you weren't thinking about that day. So don't put that on me,
No, I'm-
that if I send you to prison,
Don't talk.
that I'm somehow going to be hurting your kids or hurting your mom. You've done that. You were on felony probation, and it sounds like if the other video was played, you knew exactly what was going to happen. If what Mr. Smith is saying is true, that y'all were in that car and you said, Judge West said, I better not do this again, and you did it again, it just makes me look like an idiot for giving you the opportunity in the first place. At some point, you have to stop. At some point, you have to stop. Anything else?
Judge, even based on what she told probation is, she wants to be reinstated on probation. She was just with the wrong person. The girl she was with already took probation. I
Right.
wasn't the one stealing.
Yeah,
So she
I made a
doesn't
note of that.
accept responsibility.
How is this my responsibility?
You accept your responsibility now that we saw it on a video. You didn't accept your responsibility. You said you were with the wrong person. I'm gonna tell you like I tell everybody else. You are the wrong person. She was with the wrong person. Y'all were with the wrong, you're all, if you're in there doing it, you are the wrong person, right?
Yes, ma'am.
So you didn't take responsibility. You haven't taken responsibility. You were given this opportunity after having felonies and going to state jail for the same offense, and I gave you a probation, and I said, don't do it again. So at this time, I'm going to find again, count one, that there was sufficient evidence to find count one true, find it true, find that you pled true to counts 2 and 3, find sufficient evidence to revoke your probation, and at this time, revoke your probation, sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to,
I'll get the other one worked out today. Yeah.
okay, I'll hold it while y'all do that, and then while I'm doing that, I need a, yeah, I'll hand you the trial court certification in just a minute after y'all do that on this case that shows this was not an agreement. You have some limited rights to appeal. If y'all want to go visit about the other one, I'll hold it. All right, go ahead, go back that way. We're just going on 2.
Yes, ma'am. Yes, ma'am.
529. Thank you. I'll need, can you do one for each? It's easier for them. I'm going to mark out the second number. If you'll do 1530 on the second one, please. Mr. Smith.
You marked out 15030. I need to write 1530.
Correct. Yeah, 1530 is what that one needs to be. And we're going on multiple counts.
They can both be counts one on the judge. These are going to get 10.
All right, sir, you're Calvin Randall. And Mr. Eckhart, will your client waive the formal reading of the indictment in each case?
We do, Judge.
Mr. Randall, in cause number 24, DCCR 1529, you're charged with the second-degree felony offense of unlawfully carrying a weapon on alcohol premises, and I don't know what all those other letters stand for, IATWFZ.
That's the statutory name, Judge. I think it's in a correction facility or something like that, but it's not applicable here.
Just, I'm looking at the indictment. It says unlawful carrying weapon, alcohol premises, IATWFZ.
I've seen that before.
Weapons-free zone.
That's what it is.
Thank you, in a weapons-free zone. All right, and that is from May 17th of 2024, and how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? And then, in cause number 24, DCCR 1530, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from May 17th of 2024, and how do you plead to that charge? Again, are you pleading guilty freely and voluntarily, and because you did what they charged you with? I have here on the tablet in each of those cases some documents that have your signature on them, that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Eckhart? Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1 in each case.
No objection in each case.
It's admitted in each case. Is there any evidence that Mr. Randall is not competent?
No.
All right, Mr. Randall, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your pleas, find sufficient evidence to find you guilty, and in cause number 24, DCCR 1529, finds you guilty of evading arrest or detention. Good grief. That one is the unlawful carrying of a weapon on alcohol premises. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 1530, find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You'll also receive credit on that for any time that you've been in custody that the law gives you the right to receive. These two sentences will run concurrently, which means together at the same time. I will sign as a part of this plea agreement the dismissal in cause number 24, DCCR 1278. In each of these cases, I'm going to hand you the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. Did I do, I don't think 1529 came through. Would you?
Yes, ma'am.
They're gonna, so also I'm handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Eckhart. All right, good luck to you, sir. And we're going to get that other one printed out in just a second. I don't know what's... All right, thank you, sir. You can go back with the bailiff. We'll get it to you. Good morning, sir. You Jake Juan Fontenot?
Good morning, yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor.
And you guys have agreed to go on...
1, 2, and 3, Judge.
Mr. Fontenot, in cause number 22-39248, I have a first amended motion to revoke your unadjudicated probation, and will he waive the formal reading of that?
He will, Your Honor.
It shows that you were placed on probation December 14th of 2022 for the offense of theft of a firearm, a state jail felony, and that was a 3-year deferred probation. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department July 17th, July 23rd, and August 20th, and September 23rd of 2025. And is that true or not true?
True.
Count 2 alleges that you failed to pay your court-assessed fees as directed, and that as of September 23rd, 2025, you were $3,505 behind. Is that true or not true?
True.
And then count 3 alleges that you committed the offenses of possession of marijuana, resisting an officer, and no insurance on September 9th of 2023 in Calcasieu Parish, Louisiana. And is that true or not true?
True.
And the state's going to abandon the rest?
Yes, Your Honor.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1,
No objection.
it's admitted. Any evidence that Mr. Fontenot is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft of a firearm. Sentence you in accordance with your agreement to a term of 9 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right? Good luck to you, sir. You can go back with the bailiff. Good.
And there it is, a stark reminder of choices and consequences. In this courtroom, words were spoken, videos were shown, and yet accountability was questioned. Every decision carries weight. Every action leaves a mark. She faced the law, not as a stranger, but as someone who had been given a chance before, and yet the cycle repeated. It's easy to feel sympathy, to consider circumstances, but justice is patient, and it demands truth. In the end, this moment isn't just about guilt or innocence, it's about responsibility, and the price we pay when we fail to own it. What would you do if it were your second chance?